All right, this is a practice session for this presentation. So I'm Thaddeus Pope. This is Top 10 Informed Consent Legal Developments, Law and Policy Update on Implementing Shared Decision-Making into Clinical Practice. So the state of informed consent is not good. We have lots of studies like from the Leapfrog Hospital Survey, current standards well below what it should be. And we have lots of process measures, so measures looking at what clinicians do, right? So this one, for example, which has been replicated, listens retrospectively to 1,000 physician-patient encounters, right? And you listen to the recordings and you ask the question, how frequent was there a discussion of core risks and benefits? The answer, only 9% of the time, right? A 91% fail rate, right? We could also measure the quality of informed consent as an outcome measure. So not what are clinicians doing, but what are patients getting? So this study from the New England Journal of Medicine, which involved patients getting chemotherapy for incurable cancers. This is palliative only. Nevertheless, 30 to 40% of these patients thought it was very likely that the chemotherapy would cure their cancer, when in fact there was no chance that the chemotherapy would cure them. Right? So two problems really here. One is often the risks, benefits, and alternatives to proposed healthcare are not disclosed. And secondly, even when they are disclosed, patient doesn't understand it, patient doesn't comprehend or absorb that information, right? It's too complicated for them to get. So because of that, what I'm going to focus on now are some new laws, new legal developments that help improve the quality of consent. And this is a little bit of a spin-off of a chapter in the forthcoming fourth edition of the Oxford textbook on shared decision-making. So here's the roadmap for the next 15 minutes in 4 parts. First, medical malpractice, then federal mandates, state mandates, and then finally advanced directives. Okay, starting with medical malpractice. I think it's appropriate to start here because I think this is what people often think of when they think of informed consent. It's often framed as a tort, as one theory of medical malpractice. There were some important developments over the last year. One is more jurisprudence with respect to disclosing financial conflicts of interest. And some developments with respect to the clinician's duty to disclose their lack of experience doing the procedure at hand. But the really big news with respect to MedMal is just days ago at the American Law Institute. So the ALI voted to approve the new restatement of the law third on medical malpractice. It's just 15 sections, but 2 of those are on informed consent. And I think there's 2 key changes in those sections. One, as you know, in 25 states, the clinician's duty is set by the standard of care, right? So the physician only has a duty to disclose what other physicians customarily disclose, no matter how high or low that is. What the new restatement does is it says, we do not endorse an unqualified version of the professional standards. So even if you were consistent with what other doctors do, that's not good enough because there needs to be a minimum level, a floor of that professional standard. And then the second thing is that forever, for 50 years, informed consent has focused on what to disclose, the content, the substance. What the new restatement says is we're going to move a little bit more from the what to the how. And so disclosure, quote, must be made in a manner that is reasonably calculated to convey that to the patient. So that's tort law, right? Let's turn to federal mandates. And I think there's four worth discussing. Section 1557, some new national coverage determinations, and some developments from the FDA and OHRP. So 1557, right? A lot of patients have hearing impairment, right? About 40 million Americans. About 1 in 6 patients. And that's especially prevalent among people 50 and older, 60 and older, and then it gets very, very prevalent among patients 70 and older and 80 and older. So these patients literally cannot hear what the clinician is saying, right? Whatever is being disclosed is just not going in. So what 1557 says is that when you talk to these patients, when a clinician talks to these patients, that must be done with a qualified interpreter, whether that's going to be in person or remote. Similarly, with patients with limited English proficiency, right? They don't speak or understand or write English very well. About 25 million LEP patients, right? 1 in 13. And again, they struggle to understand what the doctor is saying. Now, of course, they can actually hear, unlike the deaf patients, hear what the doctor is saying, but they don't understand the words, right? So again, 1557 says that when you talk to these patients, you must use a qualified interpreter, whether that's in person or remote. So 2 communication duties set forth here, one with respect to limited English proficiency patients and one with deaf patients, right? So you say, okay, well, so what, right? This has been in the regs since 2016. Well, what's new is that there is significantly more enforcement, right? Enforcement from OCR, this is the case just this week, but more cases more recently. Similarly, at the DOJ, more enforcement by the DOJ in the last couple years. And then finally, third prong is more private lawsuit enforcement, right? So this case brought against the Cleveland Clinic, and in fact, then when the Cleveland Clinic didn't comply with the settlement order, got sued again successfully. But it's not just more enforcement. We also have an expansion of these 1557 duties, right? Just about 1 month ago today, you have the final rule promulgated for 1557, which makes the duties a bit broader, and secondly, makes them apply to more entities receiving federal money than previously had to comply with these duties. Okay, and those come into effect about a month from today. So that's 1557. The Food and Drug Administration. Okay, so now this one's a little bit narrower. It just applies to breast implants. And the new rule, right, is that when clinicians doing breast implants must use a patient decision checklist with the patients, going through the risks, benefits, and alternatives. And the doctor and the patient must review and sign this checklist, right? Each of these sections here. That's the FDA. OHRP, also new set of regs, and similarly focuses on not only the what must be disclosed, but goes beyond that to the where must it be disclosed and how must it be disclosed. So, for example, key information must be presented in a concise way up at the front of the document, right? So it's sort of like an executive summary. Similarly, there's a real push to use graphics and videos because they more effectively convey information to a research subject. So that's OHRP. Medicare National Coverage Determinations. So Medicare has increasingly been requiring the use of patient decision aids as a condition of payment. In other words, if you don't use the decision aid, then you don't get paid. So a decision aid is basically an evidence-based educational tool. It might be a video, might be an interactive app, might be just printed literature. More than 200 randomized controlled trials reviewed by the Cochrane, systematically reviewed, show that there are 6 big benefits from using decision aids. These patients have vastly improved knowledge, more accurate expectations from healthcare, they make more value congruent choices, higher patient satisfaction, less decisional conflict, and less patient anxiety, right? So because of that good evidence base, right, in 2015, Medicare requires shared decision making with patient decision aids. First, for screening for lung cancer with low-dose computed tomography. So this is for long-time smokers, and you get a preventative chest CT scan. But before the CT scan, the patient must receive a shared decision-making visit. That includes one or more decision aids. Why require the decision aid? Well, CMS had doubt that patients were getting accurate, unbiased, and balanced information from their clinicians. So Medicare is basically saying to these clinicians, look, your discussion with patients isn't good enough, right? And so we must supplement that, right? The patient must also get informed with the decision aid. Followed that up in 2016 with percutaneous left atrial appendage closure therapy. So this is a source of blood clots that can cause strokes. We normally treat that with a medication, warfarin, Coumadin, but now there's a device alternative called the Watchman device, which can be implanted and block those clots. But before implantation, there again must be a formal shared decision-making interaction with an evidence-based decision tool. CMS followed that up in 2018 with implantable cardioverter defibrillators, right? Little device that shocks the heart. Before implantation, again, decision-making encounter with an evidence-based decision tool. Last year, followed up with carotid artery stenting, and then it looks like next CMS is going to require this for transcatheter aortic valve replacement, right? So that's national coverage determinations. It's worth noting that Medicare does other things with respect to pushing the use of decision aids. So there's an incentive built into the MIPS scoring and formula, as well as in that for ACOs. So let's move from the feds to the states. Now, of course, there's a lot of different states doing a lot of different things. Just a couple examples. In Vermont, the rules for ACOs require that they use a decision support tool to enable a patient to assess treatment options. But the really biggest news comes out of Washington State, which is the only state that certifies patient decision aids, to vet them and approve them, right, to make sure that they're accurate, up to date, they're free of bias, they're free of conflict of interest, and they present information in an understandable way. And Washington requires that those that contract with the state, so that's going to be Washington Medicaid and the Washington State employees, that's 3 million people, use these certified decision aids. Washington also offers safe harbor legal immunity to clinicians that use a certified decision aid. So that's state mandates and incentives. Let me wrap up with advanced directives. So we are providing lots of over-treatment, or we might say unwanted treatment, or value-discordant treatment. But that's just for patients with decision-making capacity. The risk of all of that is way higher with incapacitated patients who can't speak or advocate for themselves, right? The key tool to mitigate that risk is the advanced directive, right? The problem is most adult Americans don't have an advanced directive. In the last year, the Uniform Law Commission drafted and approved a new Uniform Health Care Decisions Act, which makes it easier to complete an advanced directive, right? For example, fewer witnesses are required, fewer formalities are required to create a valid advance directive. One key example is it doesn't need to be on paper, doesn't even need to be in writing, right? Any electronic or other medium that's retrievable in a perceivable form, including a video, right? You can have a video advance directive, right? One last point is advance directives aren't really worth the paper they're written on if they aren't honored by clinicians. So there has been increasing enforcement of advance directives. So you see headlines like this, and this is something I was really happy to be involved with, that hospital staff revived a man, stopped heart, and he sued. New York Times, the patients were saved. That's why the families are suing. So what we see now that's clearer than it was just a few years ago is that non-compliance with an advance directive is a compensable injury. Right? And so we see very strong opinions come out of the Georgia Supreme Court and out of the New York appellate courts. And we see verdicts and settlements like this one for $400,000 for not following the DNR, this one for $1 million, this one for $1 million. So what we're seeing are more advance directives are being completed because of new, more accessible rules, and there's more enforcement to make sure that those advance directives get honored. So that's advanced directives. So to wrap it up, what I've given you are my top 10 informed consent legal developments. Here they are, some common law things, some federal things, and some state law things. Thank you very much.